lords, my lady. You should have on your desk, and we have sent them electronically as well, 3 separate documents. They're not there. Does your lordship have them?
Yes, I don't really do documents. You know,
We've
had all overnight to send it electronically.
We've sent them electronically, and I believe your clerk will be forwarding them to you right now. I apologise. They've been hot off the printer. What I am proposing, my lord, and I apologise that you don't have them electronically, but what I'm proposing in the first instance is that the court, rather than have me speak to this for the next 15 minutes, reads the note itself. But I'm just going to explain what the 3 documents are, and then invite the court to read the note and those documents. So there are 3. The first is a note which we have drafted pursuant to your lordship's invitation yesterday to give us 15 minutes to set out, as it were, our stall. What we've tried to do is to address to make clear what our position is on enforcement, to address some of the court's concerns and the questions that they've raised, to deal then...
So this is a 10-page skeleton argument.
Well, it's not... It's...
Filed at 10:32. I mean, it's fairly unsatisfactory, without being rude about it. It is problematic on the second day of an appeal. Is it? I mean, I suppose we better just sit and read it.
Yes, and if you do read it, my lords, what you'll see is that we're trying to assist the court in identifying where we've already dealt with these issues. So, for example, in relation to breaches, which was a understandable concern that the court raised, we do, at paragraph 14 onwards, deal with the breaches and explain the circumstances in which those breaches were raised in the court below and how they were dealt with. And then we've also provided a schedule, that's the second document, of alleged breaches, and that identifies all the policies and all the breaches that we submit have, on the evidence we have been provided with, arisen in respect of those requirements in the policies. We've identified where those matters were raised below and in the appeal skeleton. And then finally, what we've provided, as the court asked, is an order, a draft order of what we would be seeking should this court get to the point where it is considering relief.
Right, and does this document replace the 15 minutes you were?
Yes, that's exactly what I was proposing, is that the court read this instead of have me spend 15 minutes speaking to it.
When did you get this, Sir James?
Same time as you did, my lord.
Right, well, James, I think we should just rise for 15 minutes. Yeah. And read this. We'll rise for 15 minutes and read this.
have for her benefit to shield her the crime. Exactly. I see that generation of kids with school and university been completely shafted.
Can't see the plan anymore.
This is fascinating. How the age point at which you enter a year affect your social yeah. It's not just premier, it's also all sports. Yeah. But then also that example you've given to show the sort of school environment can be very positive for some people, but for some people it's a bad environment. So it's very interesting.
So my latest is to take the room back up and change it and get out of the way. It's not good for him to have me. Not necessarily him, but
Are they both still home? Yeah. Yeah. I think it's fantastic that they can stay with mum and dad. There were 6 of us. We would just poke at everyone else. Find yourself somewhere to stay.
Yeah, by the time we got to you as well.
Yeah. I was 5 or 6. Well, politely. Politely. Time to move on, buddy.
So if you guys go to university, stay at university.
Different world now. I'm surprised being in your house is probably quite nice. Yeah. But yeah, I can see that. I can see the track. Definitely see the track. Good thing he throws crap out.
Yeah.
Yeah, possibly swung too far in the other direction these days. I think it is very serious for lots of people. I think that's what lies behind a lot of the anxiety and the stress. You know.
Mine tried to.
I did check.
You did. I'm relieved. Good.
Did to
I'm unsure now.
put this stuff in my game.
We might be right.
You do have stuff faster to persuade yourself. Good. You gradually.
Always put this far. Sort of
Then you
reflection,
buy
you
into
get
it.
this approach to life.
You've got to be in this job. To some extent, why? Just hopeless. This is true. Worry about it properly, then sort of switch and just relentlessly focus on this is the case, this is the possibility, which is really excellent. Interesting. I would have thought some judges would be interested in the case that I would have thought.
Yes, Ms. Kaufman, subject to hearing from Sir James, we're minded to look at this De Bene essay, having read it, and deal with the question of whether any of this should be admitted in our judgments. But the only thing that obviously concerns me anyway is whether Sir James has a proper opportunity to be able to deal with it. I know you say it's all been there before, but I think that might be at least debatable. So you've exhausted your 15 minutes by the writing, so we will now call upon Sir James.
my lady. I'm not going to deal with the new documents right now. I'm entirely content, of course, for the court to look at those documents de NES and deal with it in that way. But I will have something to say about their lateness and their form and their structure. And we note immediately that there is still not before you any application to introduce an amended notice or grounds of appeal.
No.
I was going to go back and start with the Public Records Act, if I may, recognising, as of course we do, that some of the PRA issues at least drift towards the enforceability of policies issues, but there is a freestanding case being made, and a case that continues to be made under the PRA, and so I ought to address that and address it at the outset. Our basic submission, as you will appreciate, is that the Divisional Court were right for the reasons that they gave. The relevant provisions of the PRA are recited, including the relevant bits, or key bits of Section 1, in the judgment of the Divisional Court at paragraphs 40 to 46, and their conclusions about the interpretation of those provisions are in the judgment below at paragraphs 54 to 61. I'm sure the court would have read both sets of paragraphs. The case that was being made before continues to be made as we understand it. That case in relation to the PRA is that there's a positive duty under Section 3, subsection 1, to preserve records in effect as a precursor to selection. Such a duty, it is said, is to be implied as necessary to the duty set out in Section 3.1. That was the case below is evident, if you wanted references, perhaps most clearly from the skeleton below at paragraph 9.1, Core Bundle page 158. But if you wanted it in the pleadings, it's amended statement of facts and grounds, paragraphs 84 and 87 at Core Bundle 329. There appears to have been some attempt in the oral submissions by learned friend made to soften the nature of the duty which is alleged by introducing the idea of making arrangements for prior preservation or retention of documents. But in effect, that is not actually a softening at all. It comes to exactly the same assertion of exactly the same species of duty, because they submit that such a duty must cover all documents up to the point at which ultimate selection is made. So the duty that is asserted as implied is the one, as we understand it, that was originally pleaded and which the Divisional Court addressed. So I come to the sections themselves. It may be helpful to have those sections before you. They're behind tab 1 in the authorities bundle, and or in relation to the entirety of the Act, if that's what you're working on, the one that was handed up yesterday, or that was sent to you electronically yesterday. And I wanted to start with section 3.1 for obvious reasons. The relevant duty in section 3.1, as you see, is, quote, to make arrangements for the selection of records which ought to be permanently preserved. And that selection that must be made from public records of any description, and public records, as you know, is broadly defined in Schedule 1, especially paragraph 2.1, in effect simply defining them as administrative and departmental records. And that is, we all agree, a broad definition. I wanted to make 3 initial points on the express wording of section 3.1. Firstly, the duty is about, quote, the selection of records. And I emphasise that point because the duty in 3.1 says nothing whatever about the manner in which government or ministers or officials communicate. That was the point correctly made by the Divisional Court at paragraph 61 of the judgment. And given that the duty is about selection of records, it's also to be noted that that section says nothing whatever about the creation or the production of any particular record of any particular kind, or indeed about the retention of any particular record. It could, for example, have said you need to make a record and you need to keep records of all official government business. That is not what it said, and the example that is given in the judgment below at paragraph 59, if you just take that up, so judgment below paragraph 59, is telling and accurate. That gives the example of ministers talking in the corridor. There's nothing to preclude them doing that. They can talk in the corridor, or they can talk anywhere else about the development of policy. There's no obligation to record that oral discussion. And that is the example the court gives at paragraph 39. So it says nothing about the creation or production of any particular record. This isn't therefore driving at ensuring that records are created of discussions about government policy. That's the first point on the express wording. Secondly, as the divisional court concluded, if you just flick your eyes down into paragraph 60, there is, as they accurately there record, as they put it, a large measure of discretion as to precisely what arrangements, brackets, for selection, there should be. So even that selection duty is itself cast in the most general terms. There is no indication in section 3.1 or otherwise in the PRA from Parliament as to what sorts of records should be permanently preserved, how many of them, the criteria by reference to which that selection for permanent preservation is to be done. So arrangements import considerable discretion to the wide array of departments and linked bodies which must have those arrangements. It simply requires that arrangements of an unspecified kind be made for selection from unspecified records from an unspecified pool. And it is a wide array of public authorities. It includes individually all government departments, see paragraph 2 of Schedule 1, but it also includes bodies under such departments ranging from the Anglo-Egyptian Resettlement Board to the Wallace Collection. So it's perhaps not surprising that no attempt was made by Parliament to specify what arrangements should be, or that they should be the same in all circumstances across all those bodies. What that does is to illustrate the loose, non-prescriptive nature of the duty, even at this later stage of selection, which is all that section 3.1 is dealing with. It doesn't purport to define or even to regulate in any specific way how that is to be done. Again, it could, for example, have said you need to make the selection in order to ensure that there is a full and accurate picture from the preserved documentation of all significant government decisions. It doesn't say that. I say even at this stage of selection because there is no provision whatever, even at the high level of making arrangements for the initial preservation of records. And so we do respectfully submit that the judgment below at paragraph 61, final sentence, if you still have that to hand, is correct but understated.
I mean, the problem, Sir James, is that the keeper has given very clear directions to all government departments as to what should be preserved and what should be selected from and how the selection process should be conducted.
Well, can I come to that? I'm very conscious that that's a concern that the court has, and that the court has a concern that this is generally an important piece of legislation setting up important structures for important reasons. And I'm going to come to that if I may. I wanted to finish just on the express wording of what section 3.1 does with the third point, which is that the duty in section 3.1, as you will all have spotted, is also, it's a separate duty if you will, is also for safekeeping. That's the wording used in the tailpiece of 3.1. But that does not support, and it appears from the oral submissions is not even said nowadays to support, any case that the Act regulates the preservation pending selection of records. On the contrary, the reference is to the records which have been selected, not to those which have not. Their safekeeping, that's the wording used, refers to records in fact selected. And that suggests deliberately not setting up a safekeeping or retention duty prior to that. And again, we respectfully submit paragraph 57 of the judgment below is obviously correct and was no doubt put in there specifically to reflect and deal with an argument that was made below about safekeeping. I wanted to turn then, just before coming directly to section 1, section 3.2, to the answers that we give respectfully to the core case that is being made here, as it was below, in support of some broader duty by way of, it is said, necessary implication. But what is said, it appears, is that the duty in 3.1 must encompass a duty to retain records, because otherwise the selection process would be frustrated. And we make 4 short answers to that submission, which I don't confess to any originality in relation to any of these answers because they all occur to the divisional court. But first, just to pull them together, Parliament did not see fit to set out any such duty expressly, or indeed, as I emphasised earlier, any duty to communicate in any particular way or to create or produce records of governmental decision-making in particular or indeed all circumstances. So it was evidently not the intention of Parliament to regulate those aspects. Secondly, on the contrary, the duty it did set out was simply the high-level duty of making arrangements for selection of records for permanent preservation from the pool that is available. And there are deliberate legislative choices here. Thirdly, it might be thought that Parliament is or was vanishingly unlikely to have created duties about communication about government business or about the preservation of records more generally by implication only. Those topics, communication generally and or the creation of records, are big and complex topics with big implications of high controversy and political import, imposing potentially very considerable burdens on government and other public authorities. And if one was seeking to control those matters, if that was truly Parliament's intention, with all of those implications, all of that complexity and scale, it is little short of bizarre that none of that was set out expressly. Especially because Parliament would have had to have spelt out clearly and grappled with the policy issues to which the creation of any such duty would have given rise. What would have to be retained for selection possibly 20 years later? The logic of my learned friend's case is every record but that would impose an enormous burden and cost on government and would have to be accompanied, because the basis for that would have to be the importance of creating records of significant government decision making. It would have to be created with, it would have to be deal at the same time with some form of obligation to create the record in the first place. Otherwise you've got the unanswerable example that is given in the judgment at paragraph 59. Which is,
That's a rather unfair characterisation of Miss Covenant's case, because she accepts, and indeed everybody accepts, that many records can and should be deleted almost immediately. So I don't think it's fair to say that the logic of her case. It might be fair to say something different, which is that how do you deal with the obvious necessity to delete inconsequential records in the lead up to the 20-year period?
yes, my lord, I fully take that point, if I may respectfully say so. But my reference to every record is every record, the logic is every record of any significant government decision making. And the difficulty with that is that that's an enormous body of documentation, and it also prompts the question, if that's truly what they were trying to regulate, on the basis that it's important for records to be created and then permanently preserved ultimately of any significant government decision making, there's a completely inexplicable legislative policy lacuna in relation to the absence of any duty even to create records.
I mean, one has to consider that things have changed since 1958. And I'm not suggesting an always speaking construction, but I am conscious, because I said I was yesterday, of the way this has actually been given effect.
Yeah.
And I know you're coming to that, but the way it has been given effect, put in the broadest of terms, is that the objective is to preserve all government records, as you just said, of significant government decision making, so that the process for selection, when it's made, can be undertaken by reference to the widest possible pool of such documents.
My lord, yes. And I accept that's the way in practice it's been done. Yeah. There's a point in there about always speaking, which goes perhaps to the scale of the documentary and or electronic record issue.
1958 was a long time ago.
It was a long time ago, but in 1958 I don't imagine there was any great change in the idea that ministers sometimes spoke to each other in the corridors or in the cabinet room or in number 10 or wherever they were making policy and discussing policy. So that point remains.
I was very young, Sir James.
I'm not suggesting you were holding ministerial posts at that time, but yes, but you see the force of the point. I mean, my lord, I think my substantive answer to the point you raise, and the more significant answer to the point you raise, which is that this is the way it's been done in practice, is that is illustrative, and this is my fourth point, of a point that struck the divisional court with some force, which is that there is no lacuna. You don't end up with the Act being unworkable if you don't imply the duty. And I put it that way because, as you're very well aware from a whole series of cases, the test for necessary implication, if that's the way it's put, has been considered in the case law. One thinks of Lord Hobhouse and Morgan Grenfell and Lady Hale in the Black and Secretary of State for Justice case, but the test for necessary implication is a very high one. It's normally whether the Act is unworkable without the implication of a duty. And we respectfully submit that that isn't so if there isn't a completely odd and fundamental lacuna. The parliamentary scheme can work entirely satisfactorily without any such radical or far-reaching implication, as perhaps might be thought to be evidenced by the point my lord puts to me about the way in which it's done in practice. And we do submit that in this respect as well, the judgment below at paragraph 61 was correct. Put the point a slightly different way, the non-implication of some unspecified regulation of preservation by Parliament generally would not leave, as it were, legal badlands in place. It would simply mean that Parliament had seen fit not to regulate that territory itself, but to leave it to the good discretion, controlled by public law in the usual way, the good discretion of the government. And so there would be controls about rationality in the way in which the thing was set up. There would no doubt be in play the public law principle that you need to have regard to material considerations, including, no doubt, the existence of the obligation to make a permanent selection imposed under section 3.1. And there would be, and this was the point that was picked up specifically in the judgment below at paragraph 61, Padfield. And my learned friend Miss Kaufman sought to minimise the impact of Padfield by saying, well, you need, that's just when you're deliberately seeking to go against the statutory purpose. If Miller too is authority, good, bad or indifferent, for any proposition, it is authority for the proposition that for Padfield purposes, you do not need intent. If the effect of what you're doing is to undermine something, then you are within that territory. And no doubt there would be some point, as we accepted below and as we accept here, at which the selection process that Parliament envisages and has made provision for in section 3.1 would be undermined. There was an instruction, keep no records. But you'd have to have something that extreme, we submit, and there's no suggestion that there's anything approaching that here, indeed quite the contrary.
But may I ask you a question, Sir James, about the keeper's guidance? Would it be open to the keeper, as part of the guidance, to say you need to think about keeping certain types of records from which to make the selection?
Yes, my lady, we accept that that could be done.
Right. And that, as it were, reinforces your point that there isn't a gap.
Yeah, there isn't a gap. I mean, I'll come to it. There's a slightly kind of strange debate around precisely how section 3.2 works.
Yeah.
And you've seen the divisional court's view as to some of these policies and whether they do or they don't fall within. And to some extent, there is an obvious question there, at least, which is whether or not that role for the keeper under 3.2 is limited to duties under this section, as it says in terms.
Yeah.
And so that, to some extent, then makes it parasitic on section 3.1, if that makes sense.
I mean, let's suppose then that the keeper makes a guidance under this section saying, in order that a proper selection can be made after 20 years, you must document on a government hard drive all government policy decisions in the Department of Health. I mean, something clear and dogmatic. Is that legally enforceable if it is not done?
Well, my lord, my submission in relation to that is, my primary submission in relation to that, is that one does need to read section 3.2 as parasitic upon the duties that exist in relation to section 3.1. And the logic of my primary case on what section 3.1 means, or my case on what section...
So you say he can't give guidance about the pool, only about...
It wouldn't operate as a preclusion, but it wouldn't be statutory guidance. Is the way I would prefer.
It would be non-statutory guidance.
Yeah.
And why does that matter?
I'm not sure it does. And I'm not sure it matters whether it's statutory guidance either, other than as a point in my favour. I'm going to come back to this point, but there is an issue about this because it shades into the question of enforceability of policies. The limit of what can be done under section 3.2 is to promulgate guidance.
Can I just ask one question? You're not contending that this is so broad that it's a target duty and therefore not justiciable in any sense?
On selection?
Yes.
No.
No, thank you.
I'm not. I'm saying keep it to what they've chosen to regulate. They haven't regulated creation, they haven't regulated preservation, they've only regulated this and they've done it in a very light touch way. But just to come back to the section 3.2 point, the significance in relation to enforceability of policies, even if you conclude that this is statutory guidance issued by the keeper, it is guidance. And what Parliament hasn't done here is to do what it sometimes does, which is to specify the legal consequences of that guidance. And what that would probably mean is that this would become a mandatory relevant consideration for people to take into account, but it would still be guidance, and that doesn't sit at all well with producing a principle that says this is policy and to be treated as enforceable without good reason.
Effectively, the guidance is advisory. The duty is not on the keeper anyway, it's on the person responsible for public records. And a breach of the duty could only be established, a legal breach of the duty could only be established in the narrow circumstances relating to selection.
That's the primary submission. But my point more generally is the one that you have, because you were putting it to my learned friend yesterday. If this is statutory guidance under 3.2, how does that sit with effectively saying these are policies which are enforceable? And the position that we would make is that the debate around whether some of these policies are or are not Section 3.2 is something of a sterile one, because if it's non-statutory guidance, no doubt it would still be a relevant consideration. You'd have a debate around whether it was a mandatory relevant consideration, perhaps, but it would still be a relevant consideration, no doubt. And perhaps more significantly, if the position is that even in relation to the bit that Parliament has chosen to make specific provision about, in other words, keeper gives guidance and people operate under that guidance, if in relation to that it operates in that way as a material consideration and only as guidance, it's very difficult to see how the position could be any more onerous for government if the true position is that particular forms of policy or guidance are not produced even under the statutory rubric, but are produced, as it were, whether by the Cabinet Office in relation to the security of government business or in relation to policies which don't strictly fall within 3.2. It's very difficult to see how the position could be more onerous for government in relation to those policies in the sense of being legally enforced.
Well, you say that. I mean, but Miss Kaufman's case has now become really nothing to do with the Public Records Act at all.
Well, I'm not sure that's
I
right.
mean,
she maintained the submission that this was a necessary implication and there was a statutory duty.
Exaggeration for the sake of emphasis.
Yes, I'm going to come to enforceability.
The focus of
Yes.
the case. And the focus of the relief is certainly on things that are not to do with the PRA. And she says there is a clear government policy that says you must not use private communication methods. Let's just, the declarations she's asked for, apart from one relating to Lord Bethel, maybe two relating to Lord Bethel, all about WhatsApp messages used at the centre of government in COVID crisis. And the declarations sought are to the effect that they're unlawful because there is a policy or several policies saying you mustn't do it, right? Which is really way beyond the keeper, because it's not what the keeper says anywhere. It's what various guidance, various policy documents say. Now the question is, you obviously say if that's true, let's assume it's true that there is a quite clear policy guidance that says you must not use private methods of communication, full stop, and if you do, you have to record them, and it looks as if there may have been breaches of that. Assume it. If that's the case, why shouldn't there be? I mean, if it was clear in black and white, what might be called a clear policy of government, the epitome of government policy, why should that not be legally enforceable? Because that, I think, is the core of her
Yes,
case.
well, my lord, for all of the reasons that I'm going to come to when I deal with enforceability of policy.
Right, because anyway, but the point you're making at the moment is that it would be bizarre, I think you used that word in another connection, if the keeper's guidance in relation to 3.2, which addresses a part of this process,
is light and an unregulated thing is heavy.
Yes.
Exactly. And I mean, obviously that only goes so far. If the thing has got nothing to do with the PRA at all, then so be it. But we are in territory which is broadly to do with public records and the retention of public records for selection or otherwise.
Well,
And that is the nub of the concern.
but we might be in different territory slightly. I mean, it might be the territory of good governance and the territory of transparency, good governance, openness, in which cultural changes have occurred since 1958. And perhaps one might say, in support of Miss Kaufmann's argument, public expectations have changed. And whilst NRA is dealing with a very specific process for preservation for academic purposes and research purposes and
PRA, yeah.
PRA, I'm sorry, I was PRA.
No.
I was thinking,
National Archives.
yeah, anyway, doesn't matter. It could be said that what supports her case is separate from the PRA, as I say, for all those separate reasons, and it would be strange if government couldn't make an enforceable policy, a policy that would actually have some legal consequence, saying that it should communicate in particular ways.
Well, my lord, I'm going to come to all the arguments as to why that isn't so. Right. At the moment, I'm simply dealing with the PRA, and to the extent that, if I can limit the submission in this way, to the extent that you're in the territory of the PRA,
it would be strange.
It would be strange. And we are, at least in broad terms, if one's looking for societal values and what is to be regulated and what isn't to be regulated, one's got to consider the PRA and what Parliament has and hasn't chosen to regulate. And there's a separate question I fully accept as to whether or not in relation to any other policy to do with information management more generally. There's a separate question as to what the effect is of any government policy or guidance that is promulgated outside that rubric. I mean, it is to some extent telling, however, that in this sphere of information and record management, the gravamen of the merits of the complaint that is made against me is always the same. It always returns to, well, otherwise this is all madness, it is said, because you would have all these important government decisions about COVID or about anything else, of which there is no record. And so how can you permanently preserve for the very valuable purposes of enabling historians to see how decision-making worked, and so on? That's always the underpinning of all of this. And the fact is that that underpinning did not lead Parliament to do anything other than the lightest species of regulation at the highest level and at the latest level of selection of records. So that is the broader point about societal values. It's a point that chimes as much in relation to the PRA as it does in relation to the Freedom of Information Act, which is a piece of legislation which has now dropped off the radar in terms of the argument here, no doubt for good reason, because the real sting of the and significance of the existence of the Freedom of Information Act is that it proceeds on essentially the same foundational premise as the PRA. And it is specifically to do with affording the public a right described in frequent cases as being a thoroughly important right and a new right set up by Parliament, of giving access to the public to government's decision-making. And I use government in the broadest sense because the precondition is that you're a public authority under fire. But it starts from exactly the same premise, in the sense that that duty only applies to information which is held by the relevant public authority in effect at the date of the request. And that's a matter of accident.
Well, not complete, because,
you've got
this was drafted by parliamentarians who will have been ministers and know what systems there are for keeping important documents.
They know that, and they also know that there's a broad governmental interest for all sorts of reasons in ensuring that there is proper documentation and that it's preserved and all the rest of it for broad governmental purposes. But all of those things have been going on, if I can put it that way, forever. driven by the same fundamental underlying public interest features, and all of them have been left to the discretion of government, properly controlled by public law, and have not been the subject of intervention so as to impose duties either in the PRA or at that earlier stage under FOIA. I want to come finally to section 1, if I may. It is, of course, part of the statutory scheme, and one needs to interpret the scheme as a whole. The function of section 1, we respectfully submit, in that scheme is to set up broad functional areas of responsibility. So the Secretary of State is responsible generally for execution and for supervision of the care and preservation of public records. It doesn't create any duty to preserve or make arrangements to preserve records generally, or for the purpose of regulating selection. It's much more general than that. And it certainly does not support the implication of any such prior duty of creation of records or of preservation of records into 3.1. Quite the reverse. The true significance in context of any suggestion to that effect is the contrast in language between section 1 and section 3. Section 3.1 does impose a duty, albeit of the lightest touch regulation, statutory regulation, at the particular stage of selection.
So on one analysis, it could be said that section 1.1 says what the Secretary of State is responsible for, and section 1.2 says how that Secretary of State shall be advised on those matters, namely by the body, the ACNRA.
Yeah.
And that's all it's saying. The duty, I mean, the section is headed General Responsibility for Public Records, not duties in relation to public records.
Yes.
Whereas section 3
is a specific duty creating section.
Yeah.
And in relation to, and deals with the specific functions and the duties that flow from the functions of the keeper.
I mean, the interesting thing perhaps is that the advisory council is to advise on matters concerning public records in general.
Yeah.
And in particular on those aspects of the work of the PRA, the Public Record Office, National Archive,
Yeah.
which affects members of the public who use the facilities. So leaving the second bit, public records in general, that's very general.
It is very general. And it could be, go back to the discussion we had earlier on in relation to the more specific duty on or the more specific provision governing the keeper under 3.2, which is limited in the way that we discussed and we saw. I mean, it is possible under 1.2 that the council would see fit to give some advice about a whole range of subjects to do with public records,
Well,
including preservation.
Without giving evidence.
Yes.
I mean, it does.
It does. It does. And the question then is, where does that leave one?
But that is very clearly advice.
Yes.
And the scheme, I mean, the scheme, as I've understood, my statutory responsibilities, is that the ACNRA has advisory responsibilities. The Secretary of State has decision-making responsibilities.
Yes. And so the Secretary of State could say, thank you very much for the advice, I'm going to do the diametrically opposite.
Well, and that, I'm not sure whether that's ever happened. I think I asked that question right at the beginning when I took over, and I said, has that ever happened? And I can't remember the answer, but I think it may have happened in darkened years past, but it's certainly not frequent.
No. And one wouldn't expect it to be.
No.
But there are quite often things, that means no disrespect to either party engaged in the process. I mean, it's a bit like public inquiries that produce recommendations. I mean, in the end, there may well be policy things to do with implementation, to do with specifically taking forward particular bits of advice that would not necessarily be so evident to the advisory council that would be evident to the Secretary of State, which may lead to some feathering.
And there is a report every year under Section 1.
That was the final point I was going to make. Under 1.4, what that tells you is quite a lot about how this thing is meant to work and where the system and structures of accountability lie.
Well, and if you're interested, you can see
how it works.
My latest report in Annex 2 to the annual report of the National Archives.
Yes.
And I mean, that does say, I think, I can't claim to have written every word of it, but I certainly wrote the introduction, and it does claim, I think, to say what we do.
But my lord, it is of interest for the points that we are debating about the creation of a duty under 3.1, how far it goes, do you necessarily imply it, and all of that. It is interesting that not merely is this an act if one stands well back from it, that looks like it's very specifically picking particular areas to be the subject of legislative regulation. The underpinning of that is not bad lands, it is ordinary government discretion exercised responsibly, as the practice has indicated. And when there are controls that are built in and accountability mechanisms built in, they tend to be, and 1.4 is the paradigm example, they tend to be of that ilk, or at least that's a core part of the accountability structure that the Act sets up.
I think it's 1.3.
It's 1.3, it is. Yes, sorry.
I've just been looking at it. I mean, section 3.7 gives the Secretary of State power to decide any question about a person whose duty it is to make arrangements under this section with respect to any class of public records. And he's got a further decision-making power in para 7.2 of Schedule 1 about what counts as public records or not. So the Secretary of State, whoever he or she is, has got quite a lot of power to make specific decisions under the Act.
And again, that's all part of the same grist. It's all part of the same theme, which is it isn't even at the level at which it has chosen to regulate. It is light touch and loose for obvious and understandable reason, given the context and the nature of the issues. So that's what we say about the Act. I was going to turn to enforceability of policies, if I may. That's dealt with in our skeleton between paras 20 and 33, and the most authoritative restatement of the role of the courts in relation to policies, and a careful and, it appears, deliberate restatement of the key principles, is the A case. Lord Sales and Lord Burnett, Chief Justice, in the A case, giving that joint judgment. If you want it in the raw, it's behind tab 38, page 1312 in the authorities bundle. And the judgment relies upon and sets out extensively some passages from that at paragraph 90 to 92 in the judgment of the Divisional Court below. And that's really the key. The key bits are paragraphs 2 and 3 that you see there quoted, that I know you've read carefully. Let's see also, if you will, paragraphs 38 to 41, which themselves are worth a bit of a read because they provide some further context. But that, and I wasn't proposing to go back to it unless you wish me to, but I do emphasise at the beginning that this is the modern statement of the law. The Supreme Court, we submit, was going out of its way, a bit as it's done in other contexts, in other recent judgments, to analyse with precision and care the limited circumstances in which policies may be challenged. The core message, if I may respectfully say so, from those passages in the Supreme Court's judgment is that the position is precisely not simply that if you have a policy or a practice that will, in effect, bind the promulgator as a matter of public law, subject only to a demonstration of good reason to depart from it. It places, that's the judgment of the Supreme Court, places policies in their proper constitutional context, of which they were evidently entirely alive. And that proper constitutional and public law context included the related and basing doctrine, it might be thought, or in part basing doctrine of legitimate expectation and or relevant consideration. But there is no general principle, is the key point we respectfully invite the court to take from it, as the divisional court did. There is no general principle in public law to the effect that if you have a policy, that is something which is legally enforceable in the sense used by the divisional court. As they put it in a sentence, policies are different from law. That's the message.
Can I just ask a couple of questions on A? I mean, what A says is obviously about whether you can look at a policy for the purposes of challenging the lawfulness of that policy. What the claimants are saying, or appellants are saying in this case, is, well, you've adopted it, we're not saying it's unlawful, all we're saying is that you've breached it. And what A doesn't give us, and I wonder whether you can help us with, is any principled basis on working out when a breach of a policy will be justiciable and when it won't be.
Yes, I'm going to come to that. I'm going to make a series of submissions about the underpinning of that and how the case law is developed and how that all works to try and provide precisely that dividing line.
Thank you.
And my lord is of course right that the specific context of that was the kind of Gillick type challenge. The policy is ex facie unlawfulness. It is ex facie unlawful. But those earlier paragraphs are of significance that goes beyond, I respectfully submit, the precise circumstances of the case, which was, as my lord rightly points out, to do with that, a challenge to the face of the policy, that being one of the species of challenge. But they also consider the underpinning of it and how it all worked in those, particularly in those two general paragraphs at the beginning. And my submission is that there is no principle and no case supporting a principle that a policy made by government and directed to government that does not seek to explain or control how the exercise of government power in individual cases will be exercised is subject to that sort of legal enforceability in public law. My submission, overarching submission, is that the key feature of the cases in which the courts have held the government to policy and have enforced it in effect as law is that the government has been exercising power over individual cases in that way. And they are in the main legitimate expectation cases where in effect the policy operates as a promise as to how they're going to exercise that power. But that has been extended in a limited and careful and incremental way by cases like Mandalia, where that couldn't work, or it's very difficult to see how it will work comfortably with the doctrine of legitimate expectation, even though there's no necessary requirement for reliance. But it couldn't work comfortably with those cases because the policy in question hadn't been published. But it was still there to deal with the exercise of public power in individual cases. And there isn't anything.
That formulation of principle wouldn't be broad enough to capture, I know it's no part now of the underlying factual allegations against the respondent, but it wouldn't be broad enough to capture the Potemkin part behaviour which was alleged as part of the start of this case. Because that would be individual acts of individuals which doesn't affect anyone else. It's just keep creating records of government. And for myself, I mean, I'm sure you can come up with some formulation. For myself, I find it very difficult to accept the proposition that that wouldn't be justiciably wrong if it had ever happened.
Yes, my lord, I don't want to get sucked into too far or at all into a debate about justiciability.
Yeah.
Because justiciability is a vexed old topic, as you're very well aware. And we ran an argument based on FDA and all the complications that flowed from the ministerial code below. We're not running that here because there isn't a respondent's notice that covers that, and we're treating ourselves as it were, bound by the procedural rules that exist in the Court of Appeal. So we're not running that. Justiciability might raise a series of different questions about whether or not this is suitable subject matter for courts to rule on, or whether there are inherently manageable judicial standards, or whether you're in the territory of politics. So we are not running justiciability. If you, to come back directly to your Potemkin example, if you did, as it were, deliberately set up false meetings, I can think of a whole series of public law grounds on the basis of which you might challenge that decision. and they would include operating in good faith, and they would include operating only in the public interest. We've had various attempts to argue abuse of power where it's said that you've stepped outside the boundaries of proper constitutional behaviour. Sometimes those have failed. For example, in the context of challenge, there was a challenge to the deal that was made between the political parties in Northern Ireland and Theresa May when she was Prime Minister about how that was all going to work as an alliance, which the court rejected on political grounds. But the principle does exist. One thinks of the gerrymandering cases involving the Westminster District Council, the Westminster Council. I can't remember the name of the case, but one thinks of those cases where you're not operating.
Porter and McGill.
Porter and McGill, yes, where you're not operating in the public interest, and that is an abuse of power.
Thank you.
So that would be my answer to Potemkin, but it doesn't assist, and I don't invite you to go that far, because there would be public law principles that control it. My submission is that fact, and if it's comfort for you, that comfort doesn't help you necessarily work out where the dividing lines are in enforceable policy or not.
Thank you. Sorry to interrupt.
And I'm reminded, and entirely fairly, that the Potemkin argument below wasn't run as a breach of policy thing. It was run as a Section 3.1 argument. And of course, if you did Potemkin in the context of a 3.1 argument, you might well run into Padfield. Might be the paradigm example of Padfield. It might be thought you're deliberately subverting. Anyway, the submissions against the proposition, to come directly to where the dividing line lies and how you go about doing it, the submissions against the proposition that policies as such are subject to public law enforceability in accordance with their terms in all situations. And I deliberately put it that way because there are two parts to this argument. The first part is a proposition of law advanced by the other side that says all policies, I keep using that word, but you know what I mean. I mean, there's a serious question about whether or not something is properly characterised as a policy, but the proposition I'm addressing now is the big, broad one that is advanced against me that says all policies, because they are such, are enforceable as a matter of law, subject only to good reason. And that's an essential building block for my learned friend. I'm going to make 4 submissions about that, and then I'm going to come to these specific policies and the reasoning of the divisional court in relation to these specific policies. And you'll remember those were the 6 you looked at yesterday. I'll come to those more briefly at the end, but at the moment I'm on that. Is there a proposition of public law that if you can establish that something is a policy, it is automatically enforceable as a matter of law? And my first submission, I was going to do 4, I'm going to do 5, but the first one is incredibly short. The first one is that does not chime or sit at all well with, I put it that way deliberately to pick up the point which I accept that my Lord Justice Dingemans put to me about the precise circumstances of A, but it would not sit with the general guidance, well at all, with the general guidance that the Supreme Court gave in A, with their particular emphasis that policies are not law. Secondly, that proposition that all policies are enforceable in principle because they are policies would create a general rule of enforceability and would therefore divorce the principle from its context or from consideration of the particular context before the court. And that is an analytical technique which is pretty hostile to the way in which public law normally works. Context is all. And the divisional court here held that context was critical and that the core starting point was the one I've described from A, as they put it in paragraph 98, setting out the first principle that they derived from the authorities that they'd analysed, including Mandalia and all the rest of it. as they there said, the fundamental starting point is that policies are different from law and do not create legal rights as such, CA. We respectfully submit that's entirely accurate.
Sorry, that was paragraph 98.
98.
Divisional court or A?
Divisional court.
Ah, right, sorry.
Yeah. Now, if you get into the 90s, we're outside A.
Well, I'd worked that out.
Yeah, sorry. Yeah, 98 of the divisional court. I should have
Thank
made
you.
it clear. That's the second point. The third point is a little bit longer because it requires a little looking at, or at least thought about some of the cases. The third point is that the situations in past cases and the situations in which there may be good reason to hold government to policy as a matter of obligation do involve and have involved situations in which the decision interferes with individual rights. The cases in which the principle has been applied and policies have been held to be enforceable all concerned the application of a policy to determine an individual's rights, notably and often, but not exclusively, in the context of detention. So there is no basis for divorcing the public law principle from the particular context and seeking to derive a general proposition from those cases. There's no indication in any of those cases that they were intending to create some sweeping new ground of challenge without reference to the context. On the contrary, in most instances, the dicta and reasoning of the courts has been clearly and obviously and specifically anchored in the language of the affected individual being able to hold government to its policy. Now, if you still have paragraph 98 of the judgment to hand, we can respectfully see the force of the point which is made by the divisional court at paragraph 101 about seeing a case for not getting too strictly hung up on right, as opposed to, for example, individual benefits, say, or requests for adverse decisions to be made as against others, and so on. And so the language of individual cases may fit better, for example, with environmental policies intended to protect particular species, such as osprey or a piece of land. It's all still about the external application of policy to particular cases or rafts of cases. It's a thing of an entirely different order, we submit, to extend the principle so that it becomes an entirely general principle, that because government has promulgated something that might be described as policy, it becomes enforceable as such. And that is essentially the point that is made by the divisional court at paragraphs 101 and 102. It is, with respect, meaningless to say that this covers anything where the government is acting as a matter of public interest, because almost by definition, everything the government does is designed to further the public interest and the efficient pursuit of government, and is mostly designed to benefit the public as a whole in some way.
But, I mean, I get all that, but what if a published policy as to a use of private devices was said to be very important because of developments like the ones that they point to, COVID or, you know, really national emergencies. And what if potentially private rights were affected by the use of private devices in violation of the policy? I mean, I'm just balking at a general rule that says never.
I'm not asserting a general rule.
No, I know, but one could imagine, when one imagines a situation in which a policy about communications could possibly be very clear, publicised, because I think it could be said that some of this government policy saying don't use private devices is in the public domain, even if the policy itself is not. What I'm concerned about is there a line, or do we have to accept the incremental development of public law and say this is definitely not it? We're definitely well short of the line here, but there could be a situation where it would be enforceable, but this is not it.
Well, I think that's probably the better and the safer course, the latter, if I may say so, respectfully. And I'm sorry to have jumped in and said I'm not asserting that, but I'm not asserting the broader proposition. I'm at the moment on trying to destroy the obverse of that, which is just because it's a policy, it's automatically enforceable. And my respectful submission is it does all depend upon the context and the circumstances, which is why the divisional court's judgment is structured as it is. It looks to see, in the usual common law way, it looks to see from the past case law what are the bases of principle, how has the principle been applied in relation to what types and range of cases, and then says, well, are we in that logic? Are we in those cases? That's why it got into individual cases, outward facing and all of that, because it was seeing whether those cases had been acknowledged as the sort of context in which the courts had in the past concluded that policy should be treated in that way.
So even if what has gone on here that is pointed to in the many paragraphs of the schedule we got this morning is undesirable, put it as neutrally as one could.
It does not sound as unlawful.
It's not unlawful, you say, and there would be very severe consequences if it were.
Yes. But that allows you to take into account the particular context, the way in which the policy works, what the past cases have acknowledged. And the point I'm really on at the moment is that there is nothing in the case law, in the past case law, to indicate that the context that we've got here, which is about inward-facing policy, which is not about the exercise of public power in the sense in which it's clearly used by the divisional court, whether those features are important. And the divisional court held that they were, and we respectfully agree. But the critical third point that I'm making is that nothing in the past case law touches the sort of context that we've got here. And that's the point that the court, that's why the court went through the intensive analysis of the previous case law, including in particular Mandalia, when they were considering this. So that third point is a rather limited one. If you're doing the common law technique, look at the past cases, how much of a jump is this, are you in that territory already? That's one step in the analysis. The next element, which is the fourth submission, the next element of the common law analytical technique is to say, well, how big an extension, let's assume we're not squarely within the cases, how big an extension would it be? And normally, in public law, as in other common law, the courts proceed with some caution, no doubt bearing well in mind Lord Bingham's stricture, the ex facto orator jus, even though we're not allowed to use Latin.
I don't even understand that Latin, so if you want to tell me about it, you'll have to translate it.
And the facts drive the law.
The law comes from the fact.
Exactly.
Yeah.
Arises from.
Exactly. And so the fourth submission is that this, applying that into this principle that is asserted, would be a very considerable extension of judicial review, i.e. asserting that just because there was a policy it's generally enforceable, would be a very considerable extension of judicial review and this principle, not incremental, because it is entirely general and ignores the context. And so we submit that the divisional court were correct in their careful analysis of the origins of the policy enforceability issue and of the context in which holding government to account as a matter of law has come into being. See paragraphs 93 to 100 of the judgment below. And I don't go back to those paragraphs, I simply emphasise the following under this fourth submission. Note again under this, is this incremental or is it, because of its generality, a radical proposition? Note again the scale of the change point, particular contexts of cases in which the government has been held bound, as it were, leading suddenly to some general proposition or principle. Moreover, as the Divisional Court points out, the foundation for holding government to policy has, in the past and traditionally, been that of legitimate expectation. And that is understandable where the something like the conditions for legitimate expectation apply. In effect, what is being said is when you promulgate a policy in the immigration sphere, we will deal with this run of cases, we will deal with detention, we will deal with some other aspect of, for example, immigration in this way. You are effectively saying to the cohort of cases, you might well regulate their conduct accordingly. We're going to deal with your case in this way, at least unless there's good reason not to do so. Mandalia, if I can briefly deal with that, I'm going to come back to Mandalia. It's tab 27, page 955, rightly described by the Divisional Court as the mainstay, Divisional Court's judgment, paragraph 93 for that word, of the Good Law Project argument. Likewise, we submit, does not create a general principle. It is simply a modest incremental extension in the immigration context to that legitimate expectation underpinning, to cover the situation where the person is not aware of the policy. But nevertheless, the policy exists to guide those who have responsibility for dealing with the cohort of cases that might fall within that sphere, in that case to do with production of bank statements and so on. And indeed, it might be thought that the set of principles grounded in legitimate expectation in that way stands alongside another principle of long-standing, which provides the contrast and needs to be borne in mind when considering whether policies are always enforceable, and that is the principle identified in paragraph 111 of the judgment below, that guidance, as they put it, is precisely that and does not need to be slavishly followed. And so, in terms of the incremental or not forced submission, again, the argument appears to be that all policies are enforceable in law. Anything Ms. Kaufman said which is a true government function. And just before I pick up on that, and to be absolutely clear, I think we've covered the point already, but just to be clear about it, we note, if we may respectfully do so, the irrelevance, for your purposes, of the source of the power. No one is interested in the varies for the policies in this appeal. No one has ever said there wasn't varies or there's some varies question. We're not interested in the source of the power. We're interested in whether or not these policies are enforceable. And likewise, as I indicated earlier in answer to my Lord Justice Dingemans, we are not running, however tempting it may be, non-justiciability as an argument. So back to anything which is a true government function, as Kaufman's words, and the debate that followed the production of those words by my learned friend indicated in truth that that means everything. Whenever government is acting as government, which will be almost every time the government acts, subject only to trivial and non-controlling examples. And we've got some examples of that in the very policies that we are dealing with. Do it in a certain font, use paper rather than something else, and so I'll come back to that. But if they can't find a controlling principle, if they can't find something which doesn't make this just an entirely general principle, if the dividing line that she seeks to set up is in truth no more than an indication that this is a general assertion, then it immediately proves far too much. It would also require, if this was a general approach, it would also require engagement with the question of what constitutes a policy for the purpose of attracting this principle. And that is the subject of some consideration and some evident difficulty in the case law. You have in the bundles behind tab 46, I don't invite you to take it up now, but you have the judgment of Mr. Justice Fordham dealing with when something is or is not a policy. And there I think the allegation was built on a whole series of small documents, emails and so on, which was said to constitute a policy overall. That was said to be too elusive to amount to a policy, but whether he's right or wrong about that doesn't matter. It illustrates it's not an uncomplicated question, and you can have the same, make exactly the same basic point by reference to the Supreme Court's judgment in Friends of the Earth, Heathrow case, whereas you will recall there was something of a disagreement between the Supreme Court and the Court of Appeal on that issue. How formal did it need to be? Ought to be something that everyone can recognise as a policy immediately, rather than something which is, as it were, dragged up out of the forensic mire of ordinary government documentation. But you'd have to grapple with that as well. That's the fourth point. The fifth point is, or fifth submission, is that there is no good reason of principle to make the leap to a principle of generality, and there is very good reason for real constitutional caution. I think my Lord Justice Dingemans put the point squarely to my learned friend Miss Kaufman. There is a risk, we submit, of straying into dangerous constitutional territory of the kind deprecated by the Supreme Court in A. Now, that may be a price that is necessarily to be paid when one is dealing with individual cases, or there's something equivalent to a promise that you're going to handle particular cases in a particular way. But there are those issues there, certainly. Then there is various reference, and there's been repeated reference below and here, to various good government values that are said to make the leap an appropriate one. And I wanted to start, if I may, with Mandalia in relation to that. It's behind tab 27, page 965 in the authorities, if you would. So Mandalia, you remember, it isn't a detention case as we noted, or you noted when my learned friend introduced it. It was about producing sequences of bank statements, and just before we get to the legal reasoning in the case, is perhaps particularly notable as constituting one of the favourite forms of rejection of a submission that I made in any court. If you look at the first sentence of paragraph 33 on page 966. But back to the reasoning, paragraph 29. I've had a few.
It's a bit cruel.
I've had Lord Reed accusing me of behaving like the fat boy from Pickwick Papers and seeking to make the court's flesh creep, but I'm not doing that on this occasion at least. Paragraph 29 is the reasoning of the court. Sorry for that diversion.
We'd never do that here.
I'm very grateful. I'm rather hoping you won't reject it, but if you do, don't do it in those terms, maybe the plea. But you'll note, my learned friend took you to 29 and 30 yesterday, but you will see, I hope, that the reasoning of the Supreme Court is that incremental approach that says, well, we've got a problem here because here's the policy, here's the guidance on how it all works, and it just hasn't been published, but it is still anchored in the applicant's right to determination of his application in accordance with the policy that is being emphasised, and that's why the quote from Nataraja is apt with its reference at the end to public bodies ought to deal straightforwardly and consistently with the public. So in other words, with people who are affected by an outward-facing policy that tells them how their case is going to be dealt with in a particular way. And it's in that context that the principle of good administration is wheeled out as support for that a need to deal straightforwardly and consistently with the public in that sense. The principle, it might be thought of, consistent dealing is striking here. That principle of consistency and, as an aspect of good administration is entirely intelligible. It makes legal and practical sense, where the policy that you're dealing with is setting out how a discretionary power will be exercised in particular types of individual case. And of course, their consistency of treatment between cases is a virtue for obvious reasons. We're not in that territory here. It lacks purchase here, where the policy in question is concerned with whether or not a minister should or shouldn't have sent a particular sort of message via WhatsApp. And one does need, perhaps standing back from it, perhaps two short final points in relation to this, and then I'll turn to the individual policies. The first is that good administration as a principle cannot be equated with the judicialisation, if that's the right word, of policy. That was precisely the warning that was given by the Supreme Court in A. And ultimately, good administration has, at least as an aspect of it, the courts ensuring that they stick within their proper constitutional role and boundaries. The second and rather more general point is that the court will, I know, be careful not to blur virtuous rationale with legal obligation, or to put it another way, which I'm sure Mr. Justice Fordham would disagree with, not to treat broad values as obligation creators. And that was a point which doesn't merely flow from the A decision, but it also flows, as you will recall, from the reasoning of the Supreme Court in the Gallagher and Competition and Markets Authority case that you have behind tab 35, page 1228. And I'm not going to turn it up, you'll remember the case, but there was an attempt to elevate even something as fundamental to public law as the basic idea or concept or virtue of fairness into a freestanding ground of judicial review. And the courts were not prepared to say, well, we just take this general virtue, fairness, even fairness, good administration, consistency. We take that and we build it into some new overarching public law principle. That the very essence of the reasoning in Gallagher was that you can't do that. You need to bring it within rationality or the species of irrationality that would be no consistent treatment between equal cases and so on. The relevant references, if you want them, just for that point, again, I don't invite you to turn it up, Lord Sumption at paragraph 50, page 1247, and Lord Carnworth, paragraphs 24 to 26, starting at page 1240, especially at the end of paragraph 26. Can I turn then from the general proposition to focus more tightly on the present context? And the real sting of these submissions is going to be that they illustrate, when one comes to this context, they illustrate how far any general principle would have to extend.
Before you do that, can I just ask one question
Yes.
from the submissions yesterday? I mean, what was submitted in answer to the question I'd asked about, would this be an impermissible step, was that these were policies drafted by the government and their public law principles of consistency, absence of arbitrariness and equal treatment, dealing with like cases alike, and therefore would be within the principles that are referred to in Gallagher, because that is a freestanding public law principle. What do you say is the answer to that?
Well, my lord, they aren't necessarily the principles that sit within Gallagher. Gallagher's authority with the proposition that you need to bring them much more closely into recognised public law categories of error. So, although of course consistency, for example, and to take that is a virtue, it isn't any inconsistency which leads to unlawfulness. It has to be an inconsistency which is inexplicable and therefore irrational. Likewise, equal treatment is a jolly good thing, no doubt, but it is given expression in various statutory provisions, no doubt to do with discrimination, and in the public law principles that are related to that. So it isn't good enough simply to point to those and say, well, there we are. Here, the question is the court going to treat all policies enforceable as a matter of law? And that does drag one into the territory and isn't answered by saying, well, we're just doing that because. And I mean, I've already made the point, but it's the final point to make, perhaps to repeat by way of answer, which is that those principles, those virtues, if you will, are intelligible and sit very easily in a context where what government has done is to promulgate an outward-facing policy as to how they're going to deal with particular individual cases or categories of case. And that has no application here. So to focus more tightly on the present context, if I may, briefly, and 4 short points in relation to this focus, having made some of the points that I've already made as a matter of generality. The core point about the nature of the policies in question was indeed that one picked up by the divisional court, which is that you are not here dealing with administrative decision making in the exercise of public powers in individual cases. And if you go back to the judgment, if you would, below, you will see that that is the point that is made when deriving principles from the cases at paragraph 101 that we looked at earlier on. And you will see the same sort of point being made, or essentially the same point being made again in 102, picking it up on the 3rd sentence. Some policies, such as those in the present context, are essentially inward-facing and govern the way in which a public authority will conduct its own affairs. They do not concern the exercise of public powers, to that extent we accept the submissions of the defendants. And it's evident, therefore, that they're using that concept of public powers in the sense in which I've been using it, namely the exercise of powers to affect individual cases, and in effect a promise to treat them in a particular way. That's how they're using the concept of public powers. You can't turn up and criticise that on the basis that public powers is there a reference to government acting in accordance with its usual functions, so as to cover everything government does. They're using it in the sense described in 101 to 102, and you see that very clearly from the return to the theme when they come to deal with the individual policies. If you go forward to 110 in the judgment, these are policies, and this is why, remember this is the section with the 6 reasons as to why these ones aren't enforceable. First, these are policies which govern the internal administration of government departments and do not involve the exercise of public power. So those paragraphs need to be properly and fairly and sensibly read together. They are using that concept in the sense already described in 101 and 102. And I do submit that is important, as the divisional court found, that the policies are not of that type. But that is not to diminish the importance of the PRA or more generally of information management to government. And of course, the public may be affected by some of the policies, but only in an entirely, or at least very considerably more opaque and general way by these policies. I think worth at least reminding you that an attempt was made below to try and build an impact on the public in this way through section 5.3 of the PRA, which, as you will recall, required, I can't remember who, but required someone to afford reasonable access to those documents that had in fact been selected. It was said, therefore, the public have been given that correlative right, ergo they're being affected. That isn't an argument that is being made here. But they were right, we respectfully submit, not merely about that core and fundamental feature of the policies here, essentially about internal admin and the rules regulating government itself, not an external thing that in effect promises or states we're going to deal with your case in this particular way, whether published or not. But they were right about the more general nature of the policies here, and it is important that they were. So not just that feature of them, but here the policies cover a wide array of subjects. They relate across a big, broad field to how government should set up, manage, use, retain, etc., information of all types, affecting all its business. So a wide range of subject matters, some of which, as we discussed earlier on, I was discussing with the Master of the Rolls earlier on, have nothing whatever to do with the PRA. They come in various forms, and their nature, I submit, is not to set mandatory rules. I'll come back to that point briefly. And one needs to bear in mind, in relation to their nature, the practicalities that you discussed yesterday with my learned friend in relation to communication between ministers particularly perhaps, but communication more generally, and the difficulties of creating the perfect retention world that they assert as a matter of current obligation. It's not a good answer, we submit, to that basic nature and difficulty to say you can change it. Of course the government can change it, can change its policy, but this is a debate about the nature of these policies and whether public law should treat them now as enforceable, as they are, given their nature. No more an answer to say they can change the policies than it would be to a complaint about legislation to say Parliament can change it. These are documents which are self-evidently not overly lawyered. The language is not always precise. They provide, we submit, guidance, the identification and driving of good practice, good ways in which things can be done, rather than being designed and set up with the intent of creating a series of rules that are enforceable. We submit, therefore, that there is real force in the point that the Master of the Rolls has made on a couple of occasions, that these are, in nature, in effect, attempts to put guidance down in a fast developing area across a very wide and very complex field in a situation of considerable fluidity that should lead to flexibility and should lead or tell strongly against this being the sort of area in which it would be appropriate for the courts with their to come down, I think as the Master of the Rolls put it, with the heavy hand of the law. They serve all sorts of good public interest functions without that. That's the first point. The second point is that the statutory context is of real interest, even though some of these policies might strictly fall inside or outside, and you can have a debate about that. Can I just put that point in a try and encapsulate it in a crisp way? If one is dealing with, I'm not going to re-engage in the debate as to whether or not you are or you aren't dealing with statutory guidance, unless you want me to, but if you're dealing, assume you're dealing with statutory guidance, then we submit that the bold point is, particularly given that Parliament has deliberately refrained from making any statement on the face of the legislation, as it very often does, as to the legal significance of that guidance. But if you're dealing with statutory guidance, then it's hardly consistent to treat it like a rule of law. Lightness of touch is the hallmark of even such regulation as Parliament has seen fit to introduce. And that's limited, because it's left, as I indicated, under the statutory scheme, a very broad discretion, argument, which is entirely unregulated, to the discretion of government controlled by the looser principles of public law. But even if not, so that's a position if it is statutory guidance, it tells against them because it's guidance, not law in summary. But even if it's not statutory guidance, it's very difficult, we submit, in principle, to see why that fact, i.e. the total absence of legislative regulation, should impose a greater stricture through enforceability, or treating policies as enforceable in this context, in relation to the earlier parts of the process, if I can describe them in that way, which Parliament has seen fit to leave entirely to the discretion of government. On the contrary, that parliamentary decision, it might be thought, operates directly the other way. And that, we respectfully submit, is the point that effectively underpins and is being driven at in paragraph 112 of the Divisional Court's judgment, their third reason, which essentially deals with, it's a more specific application, if you will, of the more general point that is being made there. But I do submit that that's the significance, the overarching significance of the existence and nature of the statutory scheme. That's the second point about statutory context. The third point is that it is not necessary in the present context to impose that legal enforceability through public law in order to ensure accountability. Even before you get to paragraph 113 of the Divisional Court's judgment, which makes that point expressly by reference to other mechanisms of accountability that you've seen. Information Commissioner is one. We looked at one this morning in section 1.3 about reports to Parliament and all of that. But even before you get anywhere near that, you already have, in relation to these policies, public law controls. Rationality, material consideration, Padfield. But we do submit that paragraph 113, the third reason of the Divisional Court, is both relevant and significant. The fourth point is that the real risk of deterrence, of promulgation of guidance or policy to the positive detriment of good administration, is both a relevant and significant reason not to bring the heavy hand of the law down in this sphere. And we do submit that the judgment of paragraph 114 below legitimately took that into account for this purpose. And an aspect of that is the generality of the submission. It appears to apply, the case against me, to almost every part of the policies in the bundle. So every time a minister or a civil servant uses WhatsApp, on my learned friend's case on government business, GLP, Good Little Project, or perhaps some better placed claimant, are entitled to bring a claim for JR and to obtain relief. There are plenty of aspects of the policies that good law projects say are enforceable as a matter of law, subject to good reason not to, that will be plainly unsuitable for that status. The DHSC acceptable use policy requires all those subject to it always to carry DHSC laptops as hand luggage. Then, information management policy provides that any document printed should be printed double-sided. It also requires, that same policy, any information published externally to comply with DHSC, quote, branding guidelines. Are all those enforceable? If not, why not? What's the principle which distinguishes them? So that's what we say about enforceability of policies. Can I turn to the Dunn note, which is the third of their grounds of appeal, unless there are other aspects on enforceability of policies?
Just one question, if I may.
Of course.
In relation to the security of government business note, wasn't contended that came through the statutory scheme. So just in relation to that, one of your points then, the statutory context is of real interest, disappears, does it? Your second submission was that the statutory context is of real interest when you're dealing with statutory guidance. But this was produced inferentially under the prerogative for security of government business. So there is no statutory context.
There is no statutory context. I'm not sure I necessarily accept that it completely disappears, but it's very, very much lighter for obvious reasons, as my lord indicates. I'm certainly prepared to accept that. In the sense that it exists in relevant part to dictate and deal with things like how people can communicate and how records should be retained and so on. But obviously lighter if it doesn't sit under that rubric. Again, I'm not sure how much the court is really going to be assisted by the kind of fine distinctions as to whether or not something does or doesn't directly fall under it, because there are, as you know, that there are issues which we respectfully submit are, if not sterile, then at least of second order importance as to whether or not, for example, something falls within section 3.2 or it doesn't. The attack that is mounted against me is a general one. So I think my answer to my lord is yes, I would accept that the relevance of the overarching regimes, FOIA and indeed PRA, is of very significantly less importance in that context, perhaps not entirely over the horizon.
Thank you.
So far as the Dunn note is concerned, it appears, we thought originally that this was the one that had been singled out for challenge in this appeal. It appears that the challenge is now broader, so to some extent I'm dealing with this because it was raised as one of the grounds of appeal, despite the fact that it was barely mentioned at the hearing below, and it's hard to criticise the divisional court for not singling it out either, and despite the fact that it isn't a policy or a guidance document, but simply advice to ministers attempting to clarify existing guidance and policy. See, for that purpose, Jackson 1, she'll forgive me using her surname only, paragraph 56, supplemental bundle, page 72. This is attacked on the basis, first, that that the failure to prohibit the use of private emails or devices constitutes a breach of section 3.1, and that is hopeless, we respectfully submit, for the reasons I gave earlier. Section 3 says nothing whatever about the means of communication, and in any event, see the points we make in our skeleton at paragraph 37. Then it's criticised on the basis of inconsistency with policies, more generally, but that in effect adds nothing to ground 2. The documents are not law, there's no obligation to treat them as immutable, there's no attempt to suggest here that the policies created immutable rules in relation to non-corporate means of communication. The note does not purport to disapply the SGB anyway. It appropriately reminds ministers of the terms of the SGB, whilst also setting out, consistently with the government's position both generally and in this litigation, that the terms of the SGB are not intended to be and are not an absolute blanket prohibition in all circumstances, as opposed to the provision of best practice with a security focus. So we've dealt with the Dunn note in our skeleton, and those are the only submissions orally I wanted to.
Would you say that we have to resolve the point of construction?
My lord, I don't say you have to do that, because we submit that the divisional court was right and that stops you at the pass.
Interesting but irrelevant.
Interesting but irrelevant, and it applies to what I'm about to say as the final topic before I get to standing, but it applies to what I'm about to say about their case on breach generally. And there is a procedural issue here. The court is aware, I'm not normally an enormous fan of procedural points at this level, but there is a serious procedural question here. As has been pointed out, the grounds of appeal are clear and concise and limited. See Core Bundle, page 12. And they are tracked, at least in our skeleton. If an appellant is going to say that a divisional court, or the High Court, did not address sequential points in its judgment about which aspects of which myriad policies were breached in this, that, or the other way, and that that was wrong, and that this court can and should fill the void, as it were, then it is essential that that argument and that point is squarely and properly raised in the grounds of appeal, and it simply isn't.
Is it not covered by failure to give reasons point? Because in each of the separate grounds it says X and failure to give reasons, Y and failure to give reasons.
In the grounds of appeal?
Yeah.
But my lord, my respectful submission is that isn't good enough. You've got to raise it. I mean, we've now seen what that means. That's the significance of the documents this morning. It goes to the rather broader point my lord was raising with my learned friend yesterday. But that isn't good enough, I respectfully submit. I mean, there is a question of the jurisdiction of the Court of Appeal. The court is restricted to reviewing the decision of the lower court, CPR 5221-1, and the basis on which that is to be reviewed is confined to the grounds of appeal and, we would add, the grant of permission, which is clear from the White Book commentary at 5221.1.1. I think they there cite a case called Gover and Property Care, but it's all basic stuff. And it's far too late to be amending the grounds of appeal now, midway through or at the very end of the hearing.
Well, they haven't sought to do that.
They haven't sought to do that. And it's obviously unfair, we submit, to the respondents and indeed to the court to allow any such approach. We and the Court of Appeal are entitled to know the appellant's case. The Divisional Court didn't need to deal with any of the alleged breaches, they didn't need to. And as I say, if they wanted the Court of Appeal to go beyond that and to say that this is all perfectly tickety-boo and you could do it, then they needed to set out what the case is and what they were inviting you to do about what. It's not good enough to simply turn up and say, well, you can find disparate pellets of allegation in some of the amended statement of grounds below. And by the way, you don't need to bother with evidence, of which there was over 3,000 pages before the Divisional Court, for good or ill. They can't seek to resurrect and transmute into a more specific target the appeal in this way. And as I say, we take the prime significance of the documentation you were handed this morning as a clear indication of the thing that should have been run not merely in relation to this appeal, when the grounds of appeal went in and when permission was being sought, with a clear explanation as to how that was being done, what the case was, so the court could consider permission and then everyone was alerted to the fact that this was the game. Instead of which you now have however many pages of schedule there are, but you also have the point which I know was concerning my Lord Justice Dingemans, and we respectfully submit rightly, which is that isn't even what happened below, where you have relief cast in this entirely kind of general and freestanding way, without any attempt at specificity in territory where it is important, because there may be arguments about the proper interpretation of the policies in their true context. There may be arguments about whether something did or didn't amount to a breach. There could even be arguments around whether or not someone did or didn't breach it on behalf of government. And none of that has ever been put, instead of which you've just had a kind of shotgun blast with no tie-in to any formal species of remedy. And now, for the first time, at the very end of the appeal, you have a draft order which looks super simple and is thoroughly attractive for that purpose, until you suddenly realise that actually the sting of the order is in the 20 pages of particulars that you've now been given for the first time. So we respectfully submit that that is not an appropriate way in which to conduct an appeal, and we invite the court not to accede to it. Given that that is so, I only wanted to make some brief points in relation to some of the policies, if only for the purpose of illustrating that the thing is not quite as slam dunk and straightforward as my learned friend would have you believe. But I'm not going to deal in any detail whatever with this, because we submit that it is not an appropriate way of doing the appeal, and even if it were, and even if you were to accede to it, the court is self-evidently not in any position, both because of the absence of any dealing with it in the court below, and because it hasn't been properly raised, so it isn't the subject of such assistance as we would have been able to provide by way of written skeletons and so on. It isn't something which you could properly deal with in any event, so remittal would have to be the answer if we were to get to that stage. But we take our stand at the earlier point, or we make the earlier point as our primary case, which is that you shouldn't countenance this in any event. So with that, apologies for the counterblast, but with that procedural introduction, there are, even if the policies are enforceable here, there would be two further sets of issues at the very high level which would need to be grappled with. The first of them is a set of issues to do with interpretation, and as you know, we say that the policies, fairly and properly interpreted, are not absolute prohibitions and do not constitute such. But even if they were, depending on the policy, there may or may not have been breach. Each alleged breach of policy would have to be taken in respect of each individual policy and analysed with some care, and we certainly do not accept everything that has been said in this court about the facts, and we do not accept that that fairly or accurately reflects the totality of the evidence that was before the court below. Can I turn to the SGB, the Security of Government Business one first? And that is in the supplemental bundle. At paragraph, at page 119. This is in the statement of Sarah Harrison, 119 of the supplemental. And it's drafted using the words should rather than must. That phrasing is evidently deliberate. It means that the use of private communication channels is discouraged as a matter of best security practice. And it's consistent with the purpose of the SGB as described by Ms. Harrison as an aid memoir to ministers to provide them with advice. See for that purpose paragraphs 50 and 52. It recognises that in the modern era there will be instances where it will not be possible to ensure that all substantive government business takes place on government systems. And it is consistent also, we respectfully submit, with the point that was made by the Divisional Court in the judgment of paragraph 122, that there is real significance. This is one of the reasons for them putting down notes of caution in relation to the reasoning and analysis of Mr. Justice Chamberlain in that other Good Law Project case, which you'll recall. There is significance as to the manner in which the words are chosen. So there is significance between the mandatory and extortatory, I think was the contrast that was being made by Mr. Justice Chamberlain. There is significance there, and the Divisional Court went out of its way to say they weren't nearly as sanguine as he was. There might not be a bit of significant difference there. because, as they rightly say in 122, policy expressed in mandatory terms is different from one which simply recommends or advises a course of action. That's entirely apt, we submit, in the context of the SGB. And the court is, moreover, if you stand back from this, entitled to proceed on the basis that the SGB is aiming to assist ministers, to help them, not to set them up to fail, so that in the context of the SGB and the advice that it is giving in the real and the modern world, when you say you should not use, that means you're advised not to use. So that's the core point which is reflected, or a matter of interpretation, which is reflected across some of these other ones. If we go from there to the Cabinet Office private email guidance, that is at page 232 in the same bundle. We submit that there's nothing in there which creates a general prohibition of any sort. And the focus has been on paragraph 7, at the bottom of page 232. And my learned friend said, well, it's entirely clear here that the use of the word may in the second sentence is descriptive and not permissive. That's a pretty strange way of drafting if that's truly right. But 2 points we would make on that respect. First of all, this sort of minute scrutiny, trying to construe these documents as if they were statutes, underlines precisely how inapt this exercise it is and how unlikely it is that this sort of document was truly intending to create legally enforceable things or terms. Secondly, it isn't the natural reading of the second sentence anyway, when it follows from the first. It's a departure from that first sentence starting point without any sense of admonition, nor when it's subsequently followed at the end of the paragraph by advice to take steps to ensure that the relevant information is accessible, such as by copying across. So that aspect, this aspect, is one of general application to a number of the policies and highlights what we submit as a key difficulty with my learned friend's arguments. It's very hard to understand how, as a matter of logic, it can be said that these policies create absolute prohibitions of use in terms sufficiently clear to be enforceable, but also at the same time and in the same breath containing provision to do with what happens if it's breached. Doesn't make any sense. If the policy aim is to have no breaches, one wouldn't naturally expect there to be provision for what happens if there is a breach in this sort of document. Much more likely, we submit, to be because these policies are not intending to set absolute bright lines and bright rules of the kind that my learned friend asserts they do. And of course, if there is doubt about any of this, it doesn't merely illustrate those points, but it illustrates the potential difficulty that you would need something which obviously looked and smelt like policy for it to be the sort of thing that would attract enforceability as a principle. That was the point made by the Divisional Court at paragraph 115, its sixth reason, if you recall that one. And it chimes with the points that were being made by the Supreme Court in the Heathrow case, particularly by Lord Hodge and the Friends of the Earth that we saw earlier on, and by Mr. Justice Fordham in ZZL or ZLL. So that's that document.
Sorry, just before you leave that, you
Yeah.
referred to a may, or highlighted a may. I have not found that. Where was that?
Highlighted a may.
Yeah.
Second sentence.
Paragraph 7.
Other forms of electronic communication may be used. That's the bit that, do you remember my own friend said yesterday, well, that's not permissive, it's
Yeah, thank you, sorry. Yeah.
it's descriptive, I think was the contrast you drew.
Well, I mean, it was descriptive. You may find that government uses that people use private communications. I mean, it could mean that, but as you say, it's ambiguous.
The Cabinet Office Information and Records Management Policy.
Sorry, Cabinet Office Records Management.
Information and Records Management Policy, the IRMP. That's in this file at page 310. 303 it starts. The reliance here is placed, I think, on 3.2. And our submission shortly in relation to 3.2 is it doesn't mean that having any records in a private email account is a breach of the policy. It just means that the intention is that that shouldn't be their, as it were, their final resting place. And just to put that in context, the official repository refers to the Cabinet Office Google Drive, and you see that from paragraph 86 of Miss Harrison, supplemental bundle, page 127, and also from the first row of the table on page 328. List of approved record systems. You see the first line is Google Drive and AO Docs. And the way this is dealt with, if you go back a few pages, shared in an authorised repository, go back to page 316. It's set out in terms in the first row of the table on that page. And you will see the second column. And you will see, in particular, the second and third light bullets in the box under what this means, first set of boxes, including in particular, if we can emphasise it and invite you to underline it, at least notionally, the word only in the final bullet there. No official work should be stored only in a personal drive, laptop, or in an email account. And again, this is all inconsistent, we submit, with an absolute or any form of absolute prohibition. And the same applies in relation to the Information Records Retention and Destruction Policy, which was produced at the same time and is to be read together with this document. If you go forward to page 347, look at page 4, paragraph 4.4. And all of that is, again, we submit, all of a piece with the absence of any prohibition on them being used or stored, and rather it being, the idea being not their final resting place. But it's all underlined. Basic scope of that policy. The number 10 WhatsApp policy, 364.
Sorry, just going back to 4.4,
Yeah.
when it refers to individual email accounts, does that mean individual government email accounts or individual private email accounts? I thought the natural reading is individual government accounts, but I'm not sure.
Told it probably refers to both. That's why the scope provision is as it is. See paragraph 1.4, page 339, final bullet. And perhaps 1.5, final bullet.
Right. Yeah, okay.
Yeah. So 364, perhaps there's almost the last one, 2 more to go. 364 is the number 10 WhatsApp policy. purpose is to, as it's put, minimise the need to use personal phones for work purposes by permitting WhatsApp, not eliminating. Doesn't prohibit the use of private devices for all purposes, and wasn't intended to. See Ms. Harrison at paragraph 73, page 1, 2, 3 of the bundle. And it has retention or transfer provisions for moving WhatsApp chats onto the systems if they do become sensitive. I'll leave aside, I'm not going to repeat all the practicability points that you were discussing earlier, but you see at the foot of 164, and again the language is shouldn't. And should, if one looks at the last paragraph on page 365. And this policy was dated March 2021, and it's just perhaps worth noting as a footnote that all the Cummings WhatsApp material on which reliance is placed by Good Law Project predates this policy. Well, that might be a convenient moment. I've got two other very short documents to deal with. It'll be of a similar ilk, I'm afraid, so rather dull submissions on the remaining two documents. And then I'm going to deal briefly with standing, and then I'll be done. So I hope I shouldn't be much more than about 3/4 of an hour after lunch.
2 o'clock. Thank you.